Hello everybody. Still getting set up, but come on in. Welcome. Good to see everybody. Good evening. Hello. Good to see everyone. Hello, welcome. Welcome on in. Hi everybody. Good to see you. We've got some very interesting stuff to go over tonight. So, hello. Welcome. Welcome, everybody. Oh, my goodness. So I'm going to start the process of trying to get everything lined up properly. Oh, gone on vacation. Oh, you're back. Well, welcome back. Good to see you. Hello. Oh, yes. Very interesting, interesting stuff going on in Colorado for sure, everybody. Pre-Halloween, yes. You know, as I'm waiting for everyone to come in, let me ask something. Maybe I shouldn't ask this, but hot tea. So funny. So I made a little Halloween post on my stories. I don't know, maybe some of you have seen it, but I made a little Halloween story and just not even thinking anything of it. And some of the comments, I'm not sure. I wasn't. I forget people don't compartmentalize the same way. So I was. I'm still not. Kristen. Yeah, I'm not. I'm okay, but I keep thinking oh yeah, I mean, come on. Of course we got to rock out sometimes, but my mind's just not in the same place other people have their minds. And sometimes I just wonder how anybody gets anything done. How do you people get anything done? You're not compartmentalizing here. Oh my goodness. I just wonder is all. I just wonder. My mind doesn't work that way, so I find it very curious. Oh, thank you. Yes, we've got bologna sandwiches. Absolutely. We have some bologna going on. Yes. It's not good to compartmentalize. Well, Kristen, how do you get anything done? I swear, some of the people on this app just have one thing on their minds all the time, and it's not how to write properly in cursive. You know what I'm saying? Yes, I have one more set of I have one more set of Halloween nails that I will have for tomorrow. So I've got one more. I don't know. Oh my goodness. What's cursive? I know, right? It's a secret code. I do have one more set, so I will be doing that tomorrow. Now, tomorrow, everybody, I do plan to do a special Halloween reading, so that shall be fun. I'm looking forward to that. I'll have to be a little bit cautious, but should be pretty fun. So I've got a special set for tomorrow, Halloween and everything. So yes. Well, yeah, it's just a little Halloween post, but whatever. Just trying to have a little fun. Oh yes, bologna sandwiches. Exactly. Oh my gosh, absolutely. Yes, I should bring the ponies back, shouldn't I? I absolutely should. Oh my goodness. Oh, I'm feeling great. I'm feeling just great. Yes, I will be on tomorrow at 7. So I'll be doing a little update and then I'll be doing kind of a little reading for Halloween. So I've got some of the transcripts from the Salem witch trials, and I thought I would kind of read through that and explain it. Oh, no pictures. Nope, no pictures. Nope. But I think that will be really interesting. It's fascinating to look and see how they did trials back in the 1600s. I use the term trial very loosely, of course, but very interesting. So, yeah, I'll be kind of doing some of those readings tomorrow just as a special memorial, honestly, so we can take a moment and remember. So welcome in, everybody. Welcome. Good to see you all. Happy you could join me tonight. I do have a couple of interesting documents for us to go through. Of course, we've got the order out of the District of Columbia regarding the denial, of course, of the stay for the gag order and reissuance. I have read through the government's order. I've read through the defendant's order. And so now we've got an order that was filed last night by the judge. It wasn't actually available on the docket until this morning. So we do have it now. So I'll take you through that. And then I have a second order. I'm not sure if anybody was familiar with this one or not. Actually, I have three total. I have the demur for Mr. Floyd out of Georgia. He just filed this. Basically it's a motion to dismiss for the Georgia case. So I've got that. It's pretty short. So I'll go through that. But then I also have a grand jury indictment out of Georgia. I wasn't sure if people had heard this or not, but there is a Mr. Hansen who has been charged with making threats to Miss Fani. He's been charged now officially by a grand jury. So we've got 2 counts that he has been charged with. And so I thought I would take you through an example of another indictment here, specifically with regards to threats to the district attorney. So I've got those set up for us for tonight. So that should be very interesting. Yes, I thought it would be some interesting material to go through tonight. Had a long day. Oh, I understand. I understand. Okay, so we've got, let's go ahead and get started then with, well, thank you so much. Let's get started then with our order. I do want to make sure I filled my sticky note out properly here. So I will just get it started. This is the DC case, and this is the order on the gag order. So the order regarding reinstating the gag order here. So let me just write out my sticky note, and then I will dive right in to the documents. Sticky alert, yes. Long day 2. Day 1 of a new job. Oh, congratulations. Yes. So the disqualification case, everybody, will continue to go this week. They're planning to have it go all week. We did have testimony today of an officer who was there, and opening statements. So opening statements on both sides were done, as well as questioning of the officer, which I think will continue into tomorrow. Then we've got a couple more officers coming in, and then we also will have a couple of experts. So a couple of law professors will be coming in to testify as well. So has anyone heard if Powell's was coerced? Okay, so Marilyn, at this point, I think she has definitely been involved in some of the language around that, but has not directly been involved to a point where she would be in trouble. So they did 2 officers today. Okay, thank you. I wasn't sure. I missed the second one. I missed the second officer. So I'll have to go back and look through that. Now, another question I had for everybody was, I did see there was an interview of Miss Fani Willis that was in Georgia, and they have recorded it, and maybe we could do a watch party sometime going through that interview. I'd be very interested to see how things are going with her. So, oh, absolutely. You are welcome, Professor Pai. You're very welcome, of course. So this is the DC case. This is the gag order reinstatement. We had the gag order initially set out, and it has 4 pieces to it. He's not allowed to say or target people on the prosecutor's team, on the defense team, anyone in the court, or any witnesses or people that could be witnesses. So those are the 4 categories of people that he's not allowed to target. She paused it while it was being briefed because it was on appeal, and then she just reinstituted it. So she just let it go. It is now out in full force as of last night. So here's the order coming through. It's not particularly long, but I think it's very thorough. So here we go. Opinion and order. On September 15th of 2023, the government filed a motion to ensure that extrajudicial statements do not prejudice these proceedings. Following a motion hearing on October 16th, the court prohibited the parties and counsel in this matter from making certain public statements. Defendant has appealed that order and now moves for the court to stay the order during the pendency of the appeal. We've got that motion to stay on file. Now I have already gone through that particular document. The court entered a temporary administrative stay as to its order while the parties briefed the motion, but will now deny defendant's motion and lift the stay. We have footnote number 1. The government also asked the court to incorporate the order into defendant's conditions of release. If you remember, not only did the government say we want that order in place, but we want it actually added to those conditions, allowing for him to be out. The court hereby denies that request without prejudice, so she will not do that. Even assuming that request is procedurally proper, the court concludes that granting it is not necessary to effectively enforce the order at this time. All right, so let's get into the discussion. Number 1, 4 factors guide the decision whether to stay an order pending appeal. 1, whether the stay applicant has made a strong showing that he's likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent a stay. 3, whether issuance of the stay will substantially injure the other parties interested in the proceeding. And 4, where the public interest lies. The 3rd and 4th factors merge when the government is the opposing party. Here, all the factors weigh against granting a stay. Sub A, likelihood of success on the merits. Defendant has not made a strong showing that he's likely to succeed on the merits. As the court has explained, the First Amendment rights of participants in criminal proceedings must yield when necessary to the ordinary administration of justice, a principle reflected in the Supreme Court precedent, the Federal Rules of Criminal Procedure, and the local criminal rules. And contrary to defendant's argument, the right to a fair trial is not his alone, but belongs also to the government and the public. And she's citing the Gentile case. So this is the key case that everyone's been talking about. The public has an overriding interest that justice be done in a controversy between the government and individuals, and has the right to demand and expect fair trials designed to end in just judgments. This objective may be thwarted unless an order against extrajudicial statements applies to all parties to a controversy. The concept of a fair trial applies both to the prosecution and the defense. Defendants' repeated appeals to broad First Amendment values therefore ignore that the court, pursuant to its obligation to protect the integrity of these proceedings, recognize those values, but in balancing them against the potential prejudice resulting from certain kinds of statements, found them outweighed. Defendants' other claims, let me hit this footnote real quick, everybody. So footnote number 2. Defendant's motion argues that his speech restrictions are inconsistent with the right of listeners to receive President Trump's message. Defendant did not squarely raise the argument in his opposition brief to the government's original motion. The closest he came to identifying any authority for it was an unrelated see also citation to the Ford case, a case that he now quotes to support his right of listeners arguments. But the argument does not alter the fundamental principle that First Amendment rights, whether those of the speaker or the listener, may be curtailed to preclude statements that pose sufficiently grave threats to the integrity of judicial proceedings. Defendant's other claims also disregard the record. To begin, he asserts that the court cited no evidence supporting its findings of risk of harassment and witness intimidation, and the prosecution provided none. But several times, the court and the government pointed to evidence causally linking certain kinds of statements with those risks, and defendant never disputed it. The court, quote, when Mr. Trump has singled out certain people in public statements in the past, hasn't that led them to be being threatened and harassed, as demonstrated in the statements attached by the government? Mr. Lauro, Your Honor, that's totally irrelevant. The court and the government's motion cite several of them who averred in the kind of statements that you've asked for under oath that threats and harassment towards them had increased significantly as a result of Mr. Trump's statements about them. Undisputed testimony cited by the government demonstrates that when defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. Here she's citing the previous pleadings, failing to dispute or even discuss the testimony cited by the government. The evidence is in the record. Defendant simply fails to acknowledge it. And I think this statement is really important for her because of the appeals that she knows are on the way. So, page 4. Likewise, defendant claims that the court gave no meaningful consideration to alternative, less restrictive measures, including a narrower order. Again, the record flatly contradicts that claim. During the motion hearing, the court questioned whether defendant's existing speech restrictions, such as his conditions of release, would adequately prevent the potential dangers to these proceedings. The court also considered whether alternative measures could prevent those harms, and in fact concluded that they could with respect to certain kinds of statements, such as those disparaging the District of Columbia. Accordingly, the court denied the government's motion in those respects. So she's clarifying. She's saying if you want to complain and you want to say the District of Columbia is awful, that's fine. You can do that. But the court explained that alternative measures would not sufficiently mitigate the risks flowing from other kinds of statements, such as those targeting reasonably foreseeable witnesses. Here, alternative measures such as careful voir dire, jury sequestration, and cautionary jury instructions are sufficient to remedy only some of the potential prejudices that the government's motion seeks to address, noting that the risks created by certain statements would be irreversible. This court has found that even amidst his political campaign, defendant's statements pose sufficiently grave threats to the integrity of these proceedings that cannot be addressed by alternative means, and it has tailored its order to meet the force of those threats. The court thus tailored its order to prohibit statements only where less restrictive measures would be inadequate. So this need to have it be very narrowly tailored is the key to the First Amendment strict scrutiny test. Defendant's final claim is that the order is unconstitutionally vague for various reasons, none of which withstand scrutiny. First, defendant quotes Merriam-Webster's online definition of interested to conclude that the term interested parties could include everyone affected by or involved in the case. But interested party is a well-established legal term of art, meaning anyone who both is directly interested in the lawsuit and has a right to control the proceedings, make a defense, or appeal from an adverse judgment. So if you'll remember, he was using some particular terms in order to say it was too broad. What they mean by tailor, take out certain words he can't use. Right. So in order to meet a First Amendment test, right? So for freedom of speech, we have to have language that is narrowly tailored. So very specific, you have to carve out a very specific set of language in order for it to meet a compelling government interest. So that's what they're meaning, very specific in order to pass strict scrutiny on the First Amendment issue. So he was quoting that. She's quoting Black's Law Dictionary back. The order confirmed the scope, defining the term as including the parties and their counsel, stating that a written order would apply to the parties and their counsel. There's no meaningful basis to interpret interested parties as covering anyone else. Second, defendant focuses on the prohibition of targeting certain individuals, again quoting various dictionary definitions to assert that targeting. This was also part of the amicus curiae brief that the ACLU put in. They were saying the terms were too vague. So assert that targeting could include not only identifying those individuals, but also attacking them, subjecting them to ridicule or criticism, or otherwise attempting to affect them. But restating a dictionary to search for every facet of relevant terms is not a proper vagueness inquiry. And she's citing case law here. Rather, a statute is unconstitutionally vague if applying the rules for interpreting legal text, its meaning specifies no standard of conduct at all, and we're quoting case law here. And a cardinal rule of interpretation is that context matters. A word is known by the company it keeps, quoting case law again. The motion, hearing, and corresponding order provides substantial context for and examples of the kinds of targeting statements that could result in significant and immediate risks to the integrity of these proceedings. Indeed, the court identified that depending on their context, statements matching each of the definitions defendant proffers for the term target could pose such risks. Risks associated with publicly identifying court staff, risks associated with attacking prosecutors, risks associated with criticizing potential witnesses, and risks associated with attempting to affect potential witnesses' testimony, even using praise rather than criticism. Defense counsel also repeatedly relied on the context to distinguish permissible from impermissible statements. The court. Next hypothetical. Bill Barr is a smart guy, but he better learn to keep his mouth shut. Permissible? Or an attempt to obstruct justice or intimidate a witness. Mr. Lauro. It depends on the context. If it happened the day before Bill Barr testified at trial, that might be impermissible. A term is not rendered unconstitutionally vague because it does not mean the same thing to all people, all the time, everywhere. The court's order and motion hearings record sufficiently clarify the meaning of targeting to provide fair notice of the kinds of statements understood in context that it prohibits. Two of the defendant's social media posts since the order's entry illustrate the comprehensible difference between the statements it permits and those it proscribes. First, on October 20th. So I think this is really important. She's actually pulling out statements that he made after her order was entered. After the order was entered, but before it was administratively stayed, the defendant stated, "Does anyone notice that the election rigging Biden administration never goes after the riggers, but only after those that want to catch and expose the rigging dogs? Massive information, 100% of evidence, will be made available during the corrupt trials started by our political opponent. We will never let 2020 happen again. Look at the results. Our country's being destroyed. MAGA." This statement asserts that defendant is innocent, that his prosecution's politically motivated, and that the Biden administration is corrupt. It does not violate the order's prohibition of targeting certain individuals. In fact, the order expressly permits such assertions. By contrast, on October 24th of 2023, after the order was administratively stayed, defendant stated, "I don't think Mark Meadows would lie about the rigged and stolen 2020 election merely for getting immunity against persecution by deranged prosecutor Jack Smith. But when you really think about it, after being hounded like a dog for 3 years, told you'll be going to jail for the rest of your life, your money and your family will forever be gone, and we're not at all interested in exposing those that did the rigging. If you say bad things about the terrible monster Donald J. Trump, we won't put you in prison. You can keep your family and your wealth, and perhaps if you can make up some really horrible stuff out out him, and we may very well erect a statue of you in the middle of our decaying and now very violent capital, Washington, D.C. Some people would make that deal, but they are weaklings and cowards, and so bad for the future of our failing nation. I don't think that Mark Meadows is one of them, but who really knows? Make America great again. Yikes! This statement would almost certainly violate the order under any reasonable definition of targeting. Number 5, footnote here. Because of the administrative stay on the order, the statement is not before the court. Before concluding that any statement violated the order, the court would afford the parties an opportunity to provide their positions on the statement's meaning and permissibility. I'm glad she clarified that, actually. So she's using this as an example, but not as a means of saying that he's in trouble for it because the order was stayed at the time. Indeed, defendant appears to concede as much here. If the gag order had been in effect, President Trump would have been unable to make the statement, and for good reason. The statement singles out a foreseeable witness for purposes of characterizing his potentially unfavorable testimony as a lie made up to secure immunity, and it attacks him as a weakling and coward if he provides that unfavorable testimony, an attack that could readily be interpreted as an attempt to influence or prevent the witness's participation in this case. The plain distinctions between this statement and the prior one, apparent to the court and both parties, demonstrate that far from being arbitrary and standardless, the order's prohibition on targeting statements can be straightforwardly understood and applied. So this is really important. She's saying by his very own post, he's showing that he can comply with the very narrowly tailored order she had issued. Defendant's other assertions of vagueness boil down to similar objections that deciding whether a statement violates the order will necessarily be a fact-bound inquiry. He contends that it may at times be difficult to tell whether an individual is reasonably foreseeable witness or to distinguish proclamations of innocence from attacks on prosecutors and witnesses. But even assuming that is true, it does not follow that men of common intelligence must necessarily guess at the meaning of the order's prohibition. Citing case law here. It is a basic mistake to derive vagueness from the mere fact that close cases can be envisioned. Close cases can be imagined under virtually any prohibition. Citing case law here, if a party or their counsel makes a statement that may have violated the order, the court will assess its substance and context. The fact that it needs to do so with special care in close cases does not render the underlying order unconstitutionally vague. Consequently, defendant has failed to make a strong showing that he's likely to succeed on the merits of his appeal. So that is subsection A. So now we'll get into subsection B, remaining factors. The remaining factors also counsel against a stay. Defendant's brief arguments on each rely entirely on the premise that the court's order violated his First Amendment rights. A showing of likelihood of success of the First Amendment claim necessarily establishes irreparable injury. As for the balancing of harms and the public interests, the demonstration of an ongoing violation of the First Amendment rights dictates that a stay should be entered. So she's quoting his brief. Having rejected that premise, the court reaches the opposite conclusions, where there is no showing of a likelihood of success on the merits of a First Amendment claim. There is no irreparable injury or public interest favoring a stay. And then we're citing case law here. To the contrary, few, if any, interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors, and an outcome affected by extrajudicial statements would violate that fundamental right. Citing the Gentile case again, as discussed above in the order and during the motion hearing, the court finds that the public interest in the orderly administration of this case requires the order's limitations on such statements. Conclusion. For these reasons, defendant's motion to stay is hereby denied, and that administrative stay imposed by the court's October 20th minute order is hereby lifted. Dated October 29th, signed Judge Chutkin. All right. So she is being very clear, and what is happening here is we have a Sixth Amendment and a First Amendment battle going on. So thank you. So what she is saying is your rights, everybody's rights under the Sixth Amendment, are outweighing this freedom of speech right that the defendant is claiming here. So that due process, that fair trial, all of those rights are more important than allowing the defendant to be able to make targeted statements. Did you see his response that was filed tonight at 7? I didn't, Lisa. Has he filed another response already? Oh my gosh, I can barely keep up, everybody. Oh my goodness, I had already just come on. No, is it good? Oh dear, oh dear. Oh dear. All right, is it good? Well, I tell you what, let me ask you this. We have time tonight. Would you like me to go print it out, everybody? I can print it out. Can you explain how the first affects the sixth? I'm a bit lost. Sure, print it. Okay, begin printing it. Sure, so give me 1 minute, everybody. I'll go and print it. I've got multiple computers going, so the one I need is in the other room, so it'll take just 1 moment. So I'll be right back. Okay, actually, I already printed it. Let me see, I think, hold on a minute. The one that I see was filed earlier, before this opinion. Are you saying there is another order that came out after this opinion? Let me double check that. We should send all our paper. So the order, I have a reply for him, but I don't have anything after that reply. Let me just double check again. Let me swimming through. I don't see it on, okay, it might be on piece. Yeah, the last order that I have here is his reply brief in support of his motion to dismiss. So I do not have his response up yet at this point. So I cannot print it at this point. So sorry about that, everybody. I do like to wait until I know it's made public. Even though I do have access to Pacer, I know a lot of other people don't, so I just kind of wait until it's available. Don't see any responses. Okay. Well, I don't have any right now, but I will, we can all infer his response. I will keep my eyes peeled for it. I want access to Pacer. Well, you can, but I try to only present things that are free and available to everybody. Would it be on the docket? I did check the docket. This is the last order that I've got on the docket that's been available. He did have a reply, but I don't have anything after the judge's order here. But I'll keep my eyes out. A lot of times, when an order comes out or when something is filed on Pacer, about sometimes even just a few hours later, they will have it posted then up free publicly. So if I wait a little bit, we may have it. Why won't you share it if it's not free? Well, that's a great point. I want to make sure that whatever I'm sharing, everybody has access to. So I'm just explaining what anybody can have access to. I don't want anyone to go through and pay for anything like that, which you can do. I just prefer to make sure that it's open and available before I post about it. So if it's something that I have to use my special lawyer superpowers in order to obtain, I don't share it because I don't think it's necessarily appropriate. I like how you handle that. Well, I do try. So yes, public information. But I will wait. Typically, again, when things come out on Pacer, they do become public very soon. So I'll keep an eye out for it. I'll double check in a little bit. Oh, yes. And it should be free. It should be free. I think that's very important. There are lots of things that you can pay for, but I try to just make sure that whatever I have is free to everyone. So we've got this coming in, and I think somebody had asked real quick about a reminder of the Sixth Amendment and the First Amendment. So just as a quick reminder, the Sixth Amendment has our trial rights in it. So a right to a jury trial, a free impartial jury trial, also your right to counsels under the Sixth Amendment, your right to subpoena witnesses. So those trial rights are under the Sixth Amendment. The 14th Amendment is your due process rights for the states, although at the federal level, so any of our federal cases, which this one is, your due process rights are under the Fifth Amendment. So what she's saying in this order is your right to a fair and impartial jury is more important than your right to be able to say whatever you want under the First Amendment, which already has limitations anyway. So that was really what her piece was regarding that. Will the transcripts in the civil case in New York come out at some point? At some point, we do have pieces of some of the transcripts that have been made public, actually. Even some of the testimony from some of the witnesses already, they have made available. So there are a few places you can pull those up. Not very much yet, but pretty soon. All right, 100 million on lawyers. Oh my goodness. Yeah, I'm not surprised. It's not that much. I don't think it's that much, but how she makes the decision of which one is more important for him. Well, she's not making the decision on which one's more important for him. She's making the decision on what's more important for the Sixth Amendment because she's in charge of the criminal trial. So she's the one that makes the determination for the state and the defendant when it comes to protections under the Sixth Amendment. So that's really the key here. And again, a lot of people forget. A lot of people think, we've got a First Amendment right, freedom of speech. I can say whatever I want. And that's just not true. We have all kinds of restrictions on freedom of speech, like defamation. You're not allowed to defame people. Obscenity, no obscene language is allowed. That can be regulated. Clear and present danger, those kinds of phrases can be also regulated. Fighting words, to some extent, can be regulated. So we have all of these different doctrines that are exceptions to the First Amendment. And here, what she's saying is you've got a right to a fair trial. And so if that First Amendment is going to interfere with this fair trial out of the Sixth Amendment, that fair trial is going to take importance. Yes, exactly. And that's why if you are threatening someone or doing something like that, you can be arrested. You can be charged with that. So, and false statements as well. All right. So that is where we're at with the gag order out of DC. So let's hop over to Georgia real quick because this is very short, this demur. Slander, exactly. Slander and libel both fall under defamation. Slander, next piece here. I won't make a sticky note because it really is short. It's short and sweet here. No, that's okay, Lisa. I'm glad you brought it up. I think it's always great. I think it's good to ask questions, and then we look into it, we figure it out, and then we go from there. So, that is always okay to bring up those kinds of questions. I think that's always good. No problem with that. All right. Next we have, Mr. Floyd. All right. So let me ask, do you want the picture? Do you want me to show you the picture, everybody? I'm worried. Hold on. Let me get the picture, but I'll warn you ahead of time here. Okay. Okay, so I'm warning you, everybody. Here we go. All right, so here's Mr. Floyd. Now, Mr. Floyd was involved in Georgia. Scared? So, Mr. Floyd was involved with Miss Cuddy. I know that's not how you say her name, but I'm just very frustrated with these people, so sometimes I say their names wrong. So these two worked together along with Mr. Lee, who is a minister. These three put together a plan to pressure the poll workers in the Georgia case. So the mother and daughter team had been pressured to claim that they had been fraudulent with counting up the votes. Of course, they had not been, but they tried to kind of force that. So he was in jail, right, because he couldn't make bail. Yes, that's the one. Mr. Floyd. Yep, Miss Freeman. So these two worked together again with Mr. Lee. So, oh my goodness. So Floyd is in charge of a particular group. Now, he's been his motions, he's filed a lot of motions, but we haven't really heard much from him. But now he's got a motion for a demur that is now on file. Let me grab my calendar real quick. So his motion for demur, which is essentially a motion to dismiss. Okay, I'm taking away the picture, everybody. Bye. He has his motions for a demur and a motion to quash. Those arguments are coming up on Friday the 3rd. So those are already on the docket. But this is his demur that he has pled out in Georgia. Again, a demur is, the easiest way to look through it is to just say, it's basically a motion to dismiss. So let me take you through this. It's pretty short. Tea time. Okay, thanks, Sarah. Whew, all right, so let's get through this one. Harrison Ford, defendant Harrison Floyd, Floyd, not Ford. I wish it was Harrison Ford. That would be more interesting, wouldn't it? Defendant Harrison Floyd's general demur to count 1, issue lack of agreement to join conspiracy. Count 1 out of the Georgia case is the RICO count. Everybody was charged with count 1. And then depending on what other activities they did, were charged with other counts. There are 41 counts total. Sticky note. Okay, let's do a sticky note, everybody. Indiana Jones in court. All right, so this is the Georgia case. And this is defendant Floyd's motion for demur. Demurrer. Here, there we go. So we can put that on solo. Oh my goodness. Yes. All right. So here's his motions. He was charged with count 1, and he had the other counts specifically with regards to intimidating a witness because of the poll worker situation. So that's what he was involved in. So he does have multiple counts, but he wants to be pulled out of the RICO count, which is the only one with the mandatory minimum prison time of 5 years. And he's saying that there was no agreement to be part of the conspiracy. So a demur is basically, how would I put it? It's the mechanism where you state an indictment does not properly have all the pieces needed in order to go forward. So he's claiming there's an issue with the indictment, with the language in the indictment, as opposed to a motion to dismiss, which means that there are no proper grounds to go forward. So there's a problem with the indictment is the demur versus no grounds to go forward, which is the dismiss. But you can really put those two together, those concepts, the demur and the dismiss. They're basically the same thing. It's just a little bit different documents. Dispute of the indictment. Exactly. That's the best way to put it. As opposed to the case itself, the entire case, it's a question about the indictment. So, Floyd's attorney is creator. Really interesting. Now I've heard he's got multiple. This isn't the one where he wants language taken out because it's unflattering. No, Mads. Nope. Good memory. Nope. That was Trump in the DC case. Yes, good memory. Yeah, so much going on. He's got 3 attorneys. Okay. Oh my goodness. Oh my goodness. All right, comes now defendant Harrison Floyd by counsel pursuant to this court standing order to file 1 motion per issue and files, which I think is great because that means the judge is got pretty tight control over his courtroom here, and files his demur to count 1 of the state's political indictment. I'm going to just kind of make some notes as we go through this because it's such a short motion. So this is a buzzword here. Well, I'll just kind of make a couple notes. Political indictment entitled Violation of the Georgia RICO Act 16-14-4C. Under well-established Georgia RICO law, the state must show that Mr. Floyd knowingly and willfully joined a conspiracy to violate Georgia's RICO Act through 1 or 2 possible legal avenues. 1, by showing an affirmative agreement to the overall objective. And again, remember with RICO, we've got 1 primary master plan. So 1 master issue going on, right? And the master plan that they set out in the indictment is to keep Trump in power. That was the objective, the overall objective. That's what makes it a RICO case, because there's 1 common goal. Or 2, by showing that the defendant agreed to commit 2 predicate acts, either by words or affirmation or by actually committing the acts. Now, predicate acts are what we're referring to many times as these overt acts. Or another way that we can say it would be substantial steps. So the acts themselves don't need to be illegal, but if you look at them in connection with the master plan, with the master goal, they're helping move the master goal forward, then those are seen as predicate or overt acts. All you need are 2 under the Georgia RICO statute in order to show this conspiracy is in play. All right, so just for clarification on that. Here's footnote number 1. Hello, Amos. Good to see you. To establish a RICO conspiracy violation under Georgia law, the state must show that the defendant agreed to join or participate in the conspiracy. Citing case law here, an agreement can be shown in either of 2 ways, by showing an agreement on an overall objective, or 2, by showing that a defendant agreed personally to commit 2 predicate acts, and therefore to participate in a single objective conspiracy. And then we're citing case law. So our footnote here is just pulling case law in. Eddie was saying he only made 1 call to Miss Ruby, but yeah, interesting. I think that is very interesting. There were multiple pieces involved, so there's a lot of different acts here. And again, you only need 2 overall. And remember, we had a total of 161 bad acts. Oh, thanks, John. Oh, thanks. We had 161 acts. We only need 2 of these acts in order for there to be a RICO. So I'm pretty sure that we'll be able to find what we need in here. The court fails. So here's his demur. So here's the issues. Count 1 fails to state a crime under Georgia law because the indictment does not allege anything showing Mr. Floyd knowingly and willfully joined a conspiracy to violate Georgia's RICO Act. A, there's no allegations that Mr. Floyd affirmatively agreed to participate in the conduct and overall objective for the alleged RICO enterprise. Or B, there are no allegations Mr. Floyd agreed to commit or committed 2 or more predicate acts. And here's footnote number 2. The court's order dated October 17th, denying the demurs of Powell and Cheesebro, affirms that the state need not have asserted the defendant personally participated in even a single predicate offense to sufficiently allege the RICO count. As the court is of course aware, this exposition of the law can only be true if the state can show the defendant knowingly and willfully joined the conspiracy through one of the alternate methods, i.e. the show the defendant, i.e. affirmatively agreeing to join in the overall conspiracy or agreeing to commit predicate acts in the future. Here, Under Georgia law, a person may be found guilty of the RICO conspiracy if they knowingly and willfully joined a conspiracy which itself contains a common plan or purpose to commit two or more predicative acts. The fact that an agreement to join the conspiracy can be shown under an alternate method requiring two predicate acts does not conflate the elements of a RICO conspiracy violation with those of a substantive RICO violation. That's bologna sandwiches, everybody, all right? This is bologna sandwiches. They're fighting around the words with the language. They're saying that I didn't agree to the overall purpose, and I certainly didn't agree to two acts, and you can't really separate those things out. They're trying to pull it apart when they can't be pulled apart. If the government shows defendant agreed to the overall objective, then defendant's predicative acts are irrelevant for showing an agreement. Citing case law here, a defendant who does not commit or agree to commit the two or more predicate acts is not excused from the reach of the conspiracy provision, so long as the government can show the defendant agreed to the overall criminal plan or objective. While it is true that the conspirators can be responsible for the overt acts committed by co-conspirators, such as imputed liability based on others' actions, only comes into play after it's been shown that defendant knowingly and willfully agreed to join in the conspiracy. That is ridiculous. I'm just going to say that right now. It's ridiculous. That doesn't make any sense at all. The indictment's allegations purport to show two predicate acts at Act 120 and 121. However, since these acts arise out of or are only shown in a single transaction, there is only one predicate act, not two. Now, let me pause again before I hit footnote 3. If you will remember, one of Powell's attorney's biggest arguments that she kept arguing was that she didn't know, she wasn't involved, right? And the issue was that Fani was saying, listen, it's not about the act itself, it's about the plan. It's the plan that is the RICO charge. Again, that's the issue here. They're saying, well, I was only involved in one act. And it's like, well, wait a minute. We're not talking about the specific acts. We're talking about the plan. The plan is the RICO. So let's bump down to footnote 3 here. In order for there to be two predicate acts, the two actions must not arise out of a single transaction. It is irrelevant whether one predicate act could result in multiple criminal charges. It still constitutes only one act. And then we're citing case law here. And because I think their legal theory's off, I'm not going to take you through the legal language because I don't think that it's substantive. So popping back up again, wherefore Mr. Floyd moves this court to sustain his demur and quash count 1 of the indictment. Respectfully submitted October 27th. So it's pretty weak. It's pretty weak. It doesn't have much of legal standing here. And it doesn't seem like it was very well put together, honestly. I mean, we don't even have a full page. We've got a footnote, and our footnotes are citing case law here, which you could actually probably cite within your motion. But it's pretty lean, everybody. It's lean, stalling for time. I think they were just trying to meet deadlines. They're probably just thinking like, ooh, we should get a motion in and just toss something together. That's kind of what this seems like, is something that was quickly tossed together in order to get those the demur on the record. Was there a reply? No. Nope, no reply. So again, this is all of his motions to quash. All of the motions and various things are all set for arguments. I'm assuming they'll all be argued then on Friday. So both sides will be able to argue then. So just again as an update before I dive into this last grand jury indictment here. So here's an update on what's going on this week. We've got, I don't have where's my other one here? Here it is. We've got Colorado, the 14th Amendment. That started today. Was everyone able to find this online if they needed it? There's lots of great places for it. You can go online to Colorado Courts Online, and then you'll go to the Denver court, And then you'll go to, today it was room 209. I'm assuming it'll be 209 all week. They won't want to reset up the courtrooms. But you can do that through the Colorado courts online. Also, multiple places has been moved to the 8th. I saw that. Let me update the calendar then. But there are multiple other news places that are showing it live from different angles, as well as, yes, C-SPAN is one, and there were a couple of others. Sarah, I think you had some good other spots out there, if you're still with us, that you can share. So let me change and move Ivanka real quick while I'm thinking about it. Thank you for reminding me. I had it noted. So we had, sounds like 2 officers to date. Channel 19. Okay, thank you. Yes, channel 18. Okay. Right. So it is, you can find it online. In fact, I think I saw Forbes had it on for a little while as well. But you can go through the direct courts, or you can go and you'll just pull up Colorado 14th Amendment case oral arguments. That's the search you want to put in, and they'll have several different options. We had a couple of officers testifying today. We had opening arguments from the petitioner's side and the defense side. Defense side was, I don't know, in my opinion, from what I saw of it today, is that with the calendars, yes, I have to. I have to have something. When I was watching, I thought that the petitioners did a good job with how professional they were, but their lack of trial experience was pretty clear. But that's okay. Most attorneys don't spend a lot of time actually in trial. Defense counsel clearly had not had much trial experience, although, according to some of his statements, he kind of made it sound like he did, but I wasn't sure, particularly with his objections. Defense counsel's objections today seemed like they didn't have a lot of substance to them. So I would say the independent as well. Yes, thank you, Sarah. That's right. That's who I was thinking of. The cross was weak, yes, and I did not stay for the cross. I had been, I had things I had to do, but I will go back through and review. They did, there are some follow-ups, so I'll look through that again. But his objections, the defense's objections, were primarily, when I was watching it, were for relevance as well as clarification on some different points. So personal knowledge, those kinds of questions, which would be a Rule 600, Rule 700 question or objections. If you're in the federal rules of evidence, they're pretty weak, and he was overruled repeatedly over and over and over again. So I don't know. We will see. Everyone's just getting warmed up, I think. It took about 12 exhibits before they kind of got into the right rhythm for submitting exhibits. I think the judge was very professional and did a great job of keeping everything in order. So we will see what happens. So more will be going tomorrow on that. Yes. Will the man who wrote constitutional law be a witness? Yes, he will. Yes. I'm not sure exactly who they have listed as the con law expert, but there will be, I think, at least one. I think there's 2. They lost video but had sound. Okay, well, that's interesting. Be streamed all week. Yes, correct. Yep, all week. So they are scheduled. They have scheduled it for the entire week. So we've got today, tomorrow. I probably will be on again live tomorrow for a little bit like I was today to go through again. I would like to jump in on some cross-examination just to see how that comes together. So I will probably be going live again tomorrow, probably mid-morning. Who is that case against? That case is against Miss Griswold, who's the Secretary of State in Colorado, and Mr. Trump. So both of those are the defendants. And then with the senator from Colorado, oh my gosh, yes, we had some of those issues. And real quick, too, we had an intervening party also, which is the Republican Party in Colorado. They have intervened in the Colorado case, too, as a extra party. So they're not actually speaking, but they are present there. Will Trump be there? No. This is a civil. It's being litigated as a question of law. So we don't have. It's very much in some ways like the New York case. in that this is a question of law to be decided by a judge. So no jury's involved. Everything is being presented to a judge in order for the judge to determine the legal question of the case, as opposed to having a fact finder determining the facts in a case, which is what we need a jury for. Why are plaintiffs and not the secretary? So the Secretary of State, it's because of how the Colorado law is written, actually. Great question. So the citizens are the people who are suing. Let me just show you the case real quick, everybody, so I can give you the names on it. So we have Anderson, Priola, Camarada, Wright, and Castillan. A couple are Republicans, a couple are independents, and I think one is undeclared. And so they are all voters, and they're suing again here. Ms. Griswold, the Secretary of State, and then Mr. Trump, they're suing because they feel their rights as a voter are being infringed upon, essentially. So they're the ones trying to force the Secretary of State to conclude that he's disqualified. Because of how the law is written in Colorado, the Secretary of State doesn't really go and do their own research to determine if a candidate's qualified. That's also why the Republican Party is intervening, because the Republican Party says, according to your law, we get to pick who our candidate is, and then you have to put them on the ballot. So what they're saying is, under Colorado law, we want to force the secretary to make that determination that he is disqualified. So that's why both of them are labeled as respondents here, as defendants. So it's because of how the law is written and how they are forcing the Secretary of State to take a step beyond what her normal role would be. Now, she's been interviewed, and she is incredibly well-spoken, Miss Griswold, and explaining how the law works and how, this is a part of what is needed in order for her to be able to go forward. I got the feeling from her that she would be fine completely removing him from the ballot, but they need to have a judicial order in order for her to do it because of how their law is written. Yep. Does the amendment come before the law? The Constitution, yes, of course, is the supreme law of the land because of the supremacy clause in Article 6. So that's the key here. Is whether or not that is what's important. Was the lawyer representing Griswold? From what I could see, there were just attorneys for Trump. And when he was introducing all of the attorneys, we had a big batch of attorneys, but they were all for Trump. Citizens should decide who's on the ballot. That's a rough one. It's very interesting. Yeah, I mean, it's an interesting question, and one that, we need to take care of. We had, back in the old days, back in the beginning, we had an act actually passed. I think it was, I can't remember the name of the act off the top of my head, but it was in the 1800s, and they passed it in order to let a lot of the Confederates to come back onto ballots in different places. That was allowed under the disability clause of Section 3. So that was fine, but we've not been in a situation like this before where we have someone actually running for president in this kind of a situation. So, we need to have it decided by the courts. If he stays on or if he comes off, it has to be decided, and then that precedent will take us into the future. Happened in Oregon. The Republicans dipped out. They got removed. Really interesting. Yes. Could people write him in on ballots? Yes, they could. Just like you could write in Mickey Mouse, right? And you can write Mickey Mouse in, but Mickey Mouse can't become president. Mickey Mouse is not qualified. So if you write somebody in who's not qualified to be president under the Constitution, they can't, even if you write them in. Who is qualified to be on the ballot? Right. Well, that's the key. That's the whole key to the language. We've got the requirement of citizenship. We've got the requirement of being 35. Now, what is being argued here is whether or not that section of the 14th Amendment, Section 3, is a disqualification piece, meaning part of those original qualifications under Article 2, or if they are not meant as a disqualification. So that's the question. The scholars are arguing it out. Is more qualified than Trump. Some states have laws that write-in candidates have to file. Yes, they do. They do. I think the write-ins definitely have their own set of rules. These nuts. Popular with the millennials. Oh my goodness. Oh, that's so funny. Yes, well, maybe. I think a lot of people write in some very interesting people, for sure. But that's the case that's going on in Colorado. Now, with the Colorado case, we also have the Minnesota case. Now, I have read the Colorado case, and I think all pieces are up on YouTube now. I'm trying to kind of get those posted a little bit quicker. But I did not read through the Minnesota case. It's an interesting case, not as well written as the Colorado case, so I've not taken the time to go through it. But it's a similar situation where they are suing the Secretary of State as well as Mr. Trump to keep him off of the ballot in Minnesota. Now that's being argued in court on Thursday. My understanding is that will be televised as well. So that will be another opportunity if people want to listen to that. I have no idea who they're calling as witnesses. So write-ins in New York for cartoons are logged as void. Oh, well, that's good to know, Frank. That's very good to know. I wasn't sure. I knew everybody had their own strategy. So what about Arizona? Arizona, we do not know yet. We do not know what's going on with Arizona. Arizona and Michigan are, I think, moving into position. So I think we're going to have some things that will be filed very soon, but not as of yet. Not as of yet. Yeah, so Arizona, Michigan, I think are the two big spots. Now, New Mexico has already removed someone from the ballot, a local county local county person who was involved in January 6th. He was taken off the ballot. So far, that's the only one who has been, who the 14th Amendment, Section 3 has been used to move him off of the ballot. Any word on Pennsylvania? I know the law, the write-ins still qualified. Yes. Now, I'm not sure about Pennsylvania either. You know, I thought Pennsylvania would probably have something out by now already, but they don't. So I'm not really sure what's happening in Pennsylvania as well. I'm waiting. He was convicted. That's the big thing, Suze. He was convicted of January 6th. He was sentenced, I think, 2 weeks in jail and some fines because he was part of the coordinating of people to get to the January 6th situation. So he was found guilty, and so the judge there in New Mexico pulled him off the ballot. Yep. Well, and that's the thing too. I mean, the question is, each state then would the protocol, I'm assuming. So let's just say hypothetically, everybody, that the Colorado case wins. Let's say Colorado, Ms. Anderson and their group, they win. All right. So if they win, he's removed from the ballot in Colorado. Now you still need to get a certain number of electoral votes, right, in order to win. So there's no way he could get the Colorado votes, but we still have 49 other states. Plus, you know, the other votes like DC. So we still have every single state has its own set of electoral votes. Would other states follow suit? Yes, but not all of them. There's not kind of a federal system put into place where if Colorado said we can't put them on our ballot, all the other states would follow suit. That's not really how the process would work. It would literally be dominoes, one at a time, until they had all been contested one way or the other. So every suit would have to be brought, and then whatever precedent was set would have to be used in order to pull them off of the ballot. It'll go to the SCOTUS, absolutely. Yeah, this is going to be a U.S. Supreme Court decision, for sure. The timing of it is really the question that's in play. But yes, it will. Like, oh, thanks. Thank you. It'll take beyond the election. Exactly. I agree. I'm not sure what they will do in the interim period, though. How long is this expected for an outcome? What date is the election? So we've got the election November of next year, right? So they could fast track it up to the U.S. Supreme Court. That's absolutely possible. But again, fast tracking in the legal world, what does that mean exactly? That's a good question. 100,000. Thank you, everybody. I appreciate that. But yeah, fast tracking it to the U.S. Supreme Court would be the best bet. But again, even if the U.S. Supreme Court held that Colorado could take him off the ballot, so even if they held for that, again, all we would have is Colorado. I mean, we've got the decision in Colorado being appealed The earliest would be, spring of next year would be the earliest that the Supreme Court would probably hear it. In my guess, that would be my guess, would be the absolute earliest. And so we'd have to get it from the Supreme Court before they went on their summer break, which I think would be possible. But then we're only a couple months out of the election. So it's possible a decision could be made before November, before the Supreme Court adjourns. It's possible, but I just don't know. I don't know how fast it's going to be able to be done. And then, depending on what happens in Colorado, then all of the other states will start filing as well. And we also have Minnesota. So kind of Colorado's first, then Minnesota's next. Depending on which court makes what decision at what time, we'll see which case gets up to the U.S. Supreme Court. I would want, if it was me, I would want the Colorado case to go up to the U.S. Supreme Court rather than the Minnesota case. I think the Minnesota case is just fine, but I think the Colorado case is phenomenal. So I think this would be the one to take to SCOTUS, but that's just my humble opinion. Yeah, they need to keep the lights on in Congress first. I agree, Sheila. I agree with you on that one. Absolutely. Yep, we got to get some of that sorted out. But that's the situation that's going on with the 14th Amendment. Again, this is a case of first impression at this level, so this will be, we'll be hearing about it. This is a pretty historical moment. And then again, we've got the Minnesota case that should be televised here. Now, that should be televised on Thursday out of Minnesota. Couple of things, though, while I've got my calendar out, and then I will go into that grand jury indictment that came down here. But Minnesota does make it. Well, I think they've got some interesting points. I think they've got some good points. I just think that, in my opinion, Colorado's is just very well done, is all. That's just my humble opinion. Has there been a response to the ACLU's filing? Now, technically, there's not been any response. We also don't know if the court accepted their amicus curiae brief, but because the Judge Chutkan issued her order last night, I would say she disregarded or read and decided she didn't agree with with the brief and did her own thing. She held not in alliance with the brief, so she denied the stay, and the ACLU was requesting she grant the stay. So that's it with the amicus brief. They had a couple of good points, I thought, in there, but, Judge Chutkan came back in and said, look, that Sixth Amendment right to a fair trial is what we need to focus on here. Minnesota's got 10 electoral votes. Yeah, they do. They've got some. You got it. Yeah, exactly. You got it. All right. So the other thing that's coming up then, we had Ivanka set for Friday the 3rd to testify, but now she's being pushed to the 8th. Now, technically, Trump is supposed to testify on the 6th, so she would be testifying after him if everything stays in play as it's supposed to here. But she's been moved. There were some questions again about whether or not she had to comply with those subpoenas. She does. So she will need to come in and testify if she's subpoenaed. That is a court order. We've got Don Jr. and Eric Trump both scheduled then to be testifying this week still. So those are both on course to be testifying this week in the civil case in New York. Now, somebody had asked me about whether or not Ivanka could plead the Fifth Amendment, and that's a really good question. The Fifth Amendment, so the right against self-incrimination, really has to do with having, negative repercussions or charges against you criminally. The real issue here is because she's in civil court, the rules are a little bit different in using that Fifth Amendment. But more importantly is that most of the statutes have run. I think all of them have run. I'm not sure there could be any criminal charges against her at this point. That's the key to the Fifth Amendment. If there cannot be any criminal charges, so if immunity's been granted or the statute of limitations has run already or promises have been made, whatever it has been, or they've already pled out or already been sentenced, if there are no possible criminal charges on the table, then that Fifth Amendment is not going to have the same force. So the judge could come in and say, I get you're trying to plead the Fifth, but there's no way this could negatively affect you. So you can't incriminate yourself because you can't be charged criminally. So I need you to answer the questions. So that's where the Fifth Amendment can really come into play here. Why was she moved? Now that I don't know. That I do not know. I know Cohen had some medical issues, but I'm not sure why Ivanka has been moved. Yes, the pleading the fifth, it does have some boundaries. It does have some parameters to it. There needs to be some kind of incrimination that can negatively affect you in order to be able to invoke it, or else the judge will not let you invoke it. And then if you are ordered to answer and you don't, that would be contempt of court. It's not, yeah, it seems like Minnesota might not have enough electoral votes, but I think at anybody at this point, I think, any state, any votes at this point, I think is important to kind of set that precedent for the future, because we don't want anything like this to happen again. I think it needs to kind of be set out. Castro filing in the other states different for some reason. Yes, Angela. So Mr. Castro is a Republican candidate. He originally filed in Florida. His filing is just pretty weak. He's just saying, hey, I'm running and it's not fair to me to have competition on the ballot. The courts have just not found that to be a valid enough argument here. In Colorado, they're saying, there was an oath and that oath was violated, as opposed to saying, I've got competition and I shouldn't have competition. So we just have a couple of different issues going on. And he has filed in multiple other places, but again, they keep getting tossed out. So really, it's the Colorado and the Minnesota cases that have the most teeth. Judge will say the same thing. He has to answer because it's not a criminal case. Yes, I think so. And, the other thing, too, to keep in mind, we've got depositions for everybody. Everybody's been deposed. So when someone's testifying, they can say, I refuse to answer the question. And then the attorney can say, well, you answered it during your deposition, and can confront them with that. So refresh their memory or confront them, impeach them, which goes to their credibility. So all of the questions that they're going to ask, they're already going to have the answers to. It's just a matter of getting the witnesses to actually state it on the record. And if they choose not to, they can use those depositions as a way to force that information out one way or the other. Now, they can also say, I don't remember. We can use their depositions again to refresh their memory. So because of the kind of case this is in New York, it's not going to be very difficult at all to get the testimony that's needed to meet the burden of proof in civil court. Yes, Frank, I've noticed that it's really frustrating to you that he didn't put the proper weight down. I'm noticing that. No deposition from Ivanka. True, not necessarily a deposition from Ivanka, but she's got a lot of different documents. So, the judge had said this is a documents case, and it truly is. Every single thing is documented. There's over 1,500 pieces of evidence on file. So no matter what they ask, they're going to have a document to back it up. And so she might say, I don't remember. And then they will say, hey, is this your signature? And she'll say, yes. And then they'll say, well, what is this? And she's like, oh, this is crime or whatever. So that's how that would work. In a case like this, because it's just so clear cut, because there is so much overwhelming evidence, it's really not, we're not really going to have an issue with that. It's being reported that Ivanka Trump's testified date's been moved due to a scheduling conflict. And that could very well be. Yeah. I mean, there could be some kind of a conflict that we just don't know about. Tiny Hawk or regular Hawk? Yes. I'll have to have Hawk back on again. Yes, sometime soon I will have to. I'll have to get him back on again. But yes, so Donald Trump said if you plead the fifth, you're guilty. He did. But he did make a statement, though, during his last deposition that was done in the spring, where he said, never mind about that. So I think really, we're just going through formalities at this point. This case is so filled with so much evidence. There's really not that much that's needed. I prefer Tiny Hawk. Yes, I have to work on my computer skills, everybody. Oh, my goodness. All right. So that's the New York case. That's the update for New York. We have... let's see, we've got DC is highlighted in orange here. So we're actually off a little bit because our order just came out from the judge yesterday. But we've got Trump, Smith, Cheeley, and Schaefer hearings on demurs coming up this week on Wednesday. So that one is still set to go. Again, those demurs, just to remind everybody, are essentially motions to dismiss. So, uh-oh. Oh, here's my sheet. Everybody beware, okay? Here we go. Here we go. All right, so we've got Schaefer, Smith, Cheeley, and Trump. So they have also filed demurs, and their demur hearing will be coming up on Wednesday. Oh my gosh, thank you for the fireworks. Oh, I love that. Love that. So their hearing is coming up in Georgia. So we've got Floyd's hearing coming up, and then we have their hearings coming up on these demur motions, which again are the equivalent of motions to dismiss, specifically to the indictment issues. So they're claiming issues on the indictment. Now, remember too, a lot of our other people like Cheesebro, Powell, I think Ellis did too, also had demurs, and the judge found no problem. So he had denied the demurs before. So I think that gives us some insight into what will happen again. I'm not thinking that we're going to have an issue with these demurs, but they still need to be pled out. So I got the screen grab. Oh my gosh. No, we don't have any other guilty pleas at this point, everybody. We really don't. So, time's ticking away for the ones who are left here. Time is ticking away. The longer you wait, the less of a deal you're going to get. That's just how it works. I would say that probably Trump and Giuliani, both of these there's not going to be any deals even offered for these two. I would say Eastman and Clark would probably be very lucky to get a deal, as would Meadows at this point. Meadows is still arguing to get his case removed to federal court. He's got arguments coming up in December. His brief is due later this week. So Meadows does not have an agreement yet in Georgia. So he's still on the docket. He's still part of this. We've got Floyd again with his demur. Now he and Cuddy and Lee, one of them flips, the other two will go down. So we'll have to see which one flips first out of these three. So Floyd, Cuddy, and Lee, whoever flips first, the other two, again, will go down. So we will have to see what happens there. Mr. Roman was part of the campaign, so I'm not sure why he's hanging on for dear life either. And then Miss Hampton and Latham were both involved in the Coffee County case, where we already have two people that have pled guilty in the Coffee County case, so it would be wise for them to go forward too. We've got fake electors still and Schaefer, along with two attorneys, Smith and Cheeley. So I'm not sure who's going to be flipping next, everybody. I'm not sure. Why would the other two go down? Well, we call it something called a prisoner's dilemma, where it's just kind of a term of art that we use. When you have three people involved in a particular situation, what happens is someone will want to get out, and so they'll flip on the other two. And because these three are involved in the same piece of the indictment with the intimidation tactic, all they need is one of them to flip in order to get all the evidence to testify against the other two. So they're going to kind of have to figure out, should I flip before the other two turn on me, or should I wait and, so that I don't have to be a narc? And we'll see what happens. But the prisoner's dilemma, again, has to do with the fact that when there's more than one person involved in a crime, the other one can always flip to the other side and you can be left in the dust. Time's ticking. Exactly. That's the best way to say it. Time's ticking. Yep. So we've got the Reverend here. We've got the Mr. Floyd and Miss Cuddy, and those three are part of that witness intimidation piece of the Georgia case. Yes. What did they do? So, they tried to pressure poll workers into claiming that they had actually messed with the votes when they had not. So they were trying to use intimidation and threats. I believe Miss Cuddy actually took the poll worker to a police station and said, you need to confess to tampering with the votes, even though the poll worker had not. So they were kind of really messing with them quite a bit. So there's a lot of intimidation. No, Floyd's out. Nope, he's out. He's out. Oh yeah, no, the intimidation was real. They had a whole thing where these two were talking in front of the poll worker and making it sound like she was in huge trouble for passing a mint to her daughter, or her daughter passed a mint to her. It's ridiculous. So I have been going back through that indictment again. I need to read that out again on another live, everybody. But the details are really a lot. They're a lot. Yeah, she took Ruby to the police station. Right, right. Yeah, no, and she basically said like, "Wow, you're going to be in huge trouble if you don't go in and confess and write a statement that you messed up voting, the vote counting." And Miss Freeman was like, "I did not. I did my job. I did what I was supposed to do." And Cuddy was like, "Nope, you need to go tell him that you screwed everything up." And so that was a huge part of it. Yeah, yeah. There could be a snitches get stitches situation. Oh, absolutely. Absolutely. I think everybody's having some troubles here. Definitely some issues going on. Oh yeah, Miss Freeman. Oh my gosh, I know, unsung hero. All right, everybody. So that takes us out of the Georgia case. So let me pull this back out of that. Oh, absolutely. All right, so we've got, again, Meadows' brief is due on Friday. We've got the demur set as well. Pretrial motions in Florida are due, although who knows what's going to happen with that these days. So that's kind of the update again, the brief update, everybody. Now, I did want to take you through, it's pretty short, but there was a grand jury indictment that came down out of Georgia regarding threats that were made in Fulton County. I thought this was a very important to go through. It was under seal. It has been made public now, but I wanted to take you through kind of what some of these prosecutors are having to deal with in this situation. I believe also the sheriff was involved. So let me take you through this. It does get messier. It's getting a lot messier. All right, so this is a grand jury indictment. An indictment is a finding of probable cause a particular person committed a particular offense. It's not a finding of guilt beyond a reasonable doubt. That's what a jury trial is for. Tea, yes, tea for me. One moment, please. Tea time. And just a friendly reminder, I will be back again tomorrow at 7. I will be doing a quick overview of what had gone on for the Colorado case. I'll give you an overview, and then I'm planning to do kind of a special presentation. I will be reading through the Salem witch trial transcripts tomorrow. So just as kind of a recognition here, acknowledgement of and memorial to some of the things that have gone on in our history. Thank you for your dedication. Oh, you're welcome. Of course, of course. All right, sticky note, everybody. So I'm going to just put Hansen indictment on here. I'm not sure that's even going to make much sense, but it should be able to be understood as I go through it. So that'll be very interesting. Yes. Oh, yes, it is. It's very interesting. Now, the language can be a little bit difficult to understand, so that's why I thought it would be interesting to kind of walk through some of those terms again. So I've got a couple of actual depositions that were taken during the Salem witch trials and some testimony. So I want to take everybody through that, and we can kind of talk about that. All right, here we go, everybody. So here's the indictment. Introductions. At all times material to this indictment, the defendant, Arthur Ray Hansen II, lived in or around Huntsville, Alabama. What time? Tomorrow, 7 o'clock Central, I'll be going. Fonnie Willis was elected district attorney for Fulton County, Georgia, was investigating a case involving former president of the United States, Donald J. Trump. Patrick Labatt was elected sheriff for Fulton County. Okay, it was sheriff. I wasn't sure if it was a sheriff or a deputy. And was in charge of the operation of the Fulton County Jail, where Fulton County criminal defendants are often received into custody and photographed. Count 1. The grand jury realleges and incorporates by reference the factual allegations contained in paragraphs 1 through 3 of this indictment as if fully set forth herein. I feel like by the end of all of this, everyone will be able to write an indictment up. You can all go and work for a law office somewhere writing indictments, because we've all read through so many of them together by this point. Oh my goodness. All right, so here we go. On or about August 6th of 2023 in the Northern District of Georgia and elsewhere, the defendant, Mr. Hansen, consciously disregarding a substantial risk that his communication would be viewed as threatening violence, knowingly transmitted a communication in interstate and foreign commerce from the state of Alabama to the state of Georgia that contained a threat to injure Fulton County Sheriff Patrick Labatt. Specifically, Hansen called the Fulton County Government Customer Service line and left a voicemail message for Sheriff Labatt in which Hansen made statements which included, but were not limited to, the following. I am going to directly read these, so viewer discretion advised if you're sensitive. If you think you're going to take a mugshot of my President Donald Trump and it's going to be okay, you're going to find out that after you take that mugshot, some bad shiz probably going to happen to you. If you take a mugshot of the president and you're the reason it happened, some bad shiz is going to happen to you. I'm warning you right now before you F up your life and get hurt real bad. Yikes. Whether you got a goddamn badge or not ain't gonna help you none. And you gonna get effed up. You keep effing with my president. Oh my gosh, I feel like I just hurt my brain. Best live reading. Sorry, everybody. Sorry. Viewer discretion. All in violation of Title 18 United States Code, Section 875 sub C. Count 2. The grand jury realleges and incorporates by reference the factual allegations contained in paragraphs 1 through 3 of this indictment as if fully set forth herein. On or about August 6th of 2023 in the Northern District of Georgia and elsewhere, the defendant, Mr. Hansen, consciously disregarding a substantial risk that his communication would be viewed as threatening violence, knowingly transmitted a communication in interstate and foreign commerce from the state of Alabama to the state of Georgia that contained a threat to injure Fulton County District Attorney Fonnie Willis. Specifically, Hansen called the Fulton County Government Customer Service line and left a voice message for District Attorney Willis in which Hansen made statements which included but were not limited to the following. Okay, everybody, bear with me. Direct quotes, viewer discretion. Watch it when you're going to the car at night, when you're going into your house. Watch everywhere that you're going. I would be very afraid if I were you because you can't be around people all the time that are going to protect you. There's going to be moments when you're going to be vulnerable. When you charge Trump on that fourth indictment, anytime you're alone, be looking over your shoulder. And what you put out there, B-word, comes back at you 10 times harder, and don't ever forget it. End quote. Yikes. All in violation of Title 18 United States Code, Section 875 sub C. True bill, according to the grand jury indictments. That's a lot, everybody. That's a lot. So we've got two huge threats, one against the sheriff in Fulton County, one against Miss Fonnie Willis. He has been indicted on both of those charges. Holy moly. I know. Very aggressive. So they're not kidding around. They're getting a lot of threats. And again, this was all the way back in August, too. The first one was the sheriff. Yes, that's right, Rich. Yep, exactly. So he has been indicted. This was a voicemail. Yes. So he called up customer service and left voicemails for them. What's the next step? So now that he's been indicted, he should be pulled in and arrested and then go through the procedures for that for that arrest. Why does it also sound like a fifth grader? Yeah, that's a good question. I don't know. I think, people say some really ridiculous things, but, anytime you're being recorded, everybody, I mean, that's hashtag evidence. You know what I'm saying? I feel like a ghost wrote the second one. Maybe. Yeah, I mean, he was 59. Oh, my goodness gracious. Yeah, so, this again, some people would say, well, he's got a First Amendment right to say what he wants. No, you don't. The First Amendment does not allow for threats like this. So these kinds of threats are not protected by the First Amendment. And so, Yeah, yeah. So here, with these kinds of threats, you're going to be facing some significant charges, particularly with a prosecutor and a sheriff. Yeah, so much anger. Yeah, it's really sad. And I think that's one of the things that we're all really struggling with here is that we have basically, just the equivalent of mail carriers. Like, this is just their job. This is the prosecutor's job. This is the court personnel's job. And yet they're getting all these threats. They're getting things. I mean, in New York, the law clerk's getting picked on. I mean, we've got the judge getting threats in DC. I mean, they're just doing their job. They're just doing their job. But, people are coming after them. So it's a lot. Yeah, it's a lot. It's a lot. Now, I know the grand jury indictments come out and has been unsealed. As far as where he's at in the whole process, that I do not know. That I do not know. Yeah, he's definitely, they do it to everyone. Oh yeah. I mean, it's a lot. But again, I mean, if you think about it, it's one thing, for law enforcement. I don't have too much sympathy. Don't get me wrong. I've got respect, but sometimes law enforcement, you got to call them out. But if you're calling somebody out just because they're taking a mugshot photo or just because they're filing paperwork because it's their job, it's difficult. It's a difficult situation. Yep. Afraid to put Trump in jail. I don't think the judges are afraid to do that. I think the judges are afraid for their staff. I absolutely, truly believe the judges are afraid for their staff. Judges, every single day of their lives are afraid that a unhappy defendant is going to come and get them. So they live with that every day. But their staff can leave that at the office when they go home. But in these kinds of cases, it's more difficult and they're unable to do it. And that's why we're seeing this gag order in New York. That's why we're seeing the gag order in DC, because it's this idea that it's the court personnel, that the paralegals, the clerks, the court reporters, all of the administrative assistants, because it takes a village to run a trial, and they are all struggling. So I think it's definitely an issue. Can the staff have police protection? They can, but it's expensive. I think I had seen somewhere where Jack Smith, for his team, has spent millions on U.S. Marshal protections for his staff and for him. And they've spent millions on it. And you get a local community here like Fulton County where the resources are already as tight as possible. It's going to be almost outside of the realms of reality to be able to pull staff in for protection. Was it 4 million? Yeah, it's a lot. I mean, millions. It's been a lot. You think he'll either be in jail in Georgia or DC sooner rather than later? I'm tired of waiting. Oh, I know, Don. I know. A lot of people are tired of waiting. I have no idea. I really have no idea at this point. I really have no idea what's going to happen. He's not being treated like a regular defendant. If he was a regular defendant, I would have answers for you already. But he's not. He is being treated completely different than a normal person. So I do not know what's going to happen. His witness protection is expensive. Oh, absolutely. Absolutely. He'll get contempt charge for the gag order. It's possible. I think the judge in New York is probably the best bet at this point, because I think that judge has just about had enough. You get that feel from him. So I think for sure. Oh, absolutely. Especially in family court. It's very difficult. It's very difficult. And, too, when I was a prosecutor, every time you left the courthouse, you knew that someone was going to come for you. And that's just how you lived every day. I remember just even going to the grocery store after my first couple of sentences for prison time and thinking, if this person's family is in the grocery store, I'm going to have to go hide behind the ruffles because there's not a lot I can do to protect myself. It's a dangerous job. It is a very dangerous job. It is. And ultimately, it was the safety of myself and my family that was one of the big reasons why I left that position, because it just wasn't worth it. we got to do it. We got to do it. Ruffles have ridges, but I don't think they're bulletproof. You know what I'm saying? But it's scary. It's scary, and their families are affected too. And, I think we heard some of that testimony during the Jan 6th hearings where we were listening to Raffensperger and his wife. They had all kinds of threats and things. I mean, it's true. It's true. Well, yeah. Yeah, it's difficult. It's difficult. Can you be showing this document per ABA 1.3? Absolutely, Colin. I absolutely can. Although, good for you for looking up the American Bar Association Rules of Ethics. I have them as well as along with my state's Rules of Ethics. Absolutely. So no legal advice here, legal education only. And that's just how they go. Marcia. I know. Some people will lose their minds over things. It's true. It's very true. Oh, absolutely. It's tough, everybody. It's tough. And, tensions and emotions run high, and it makes sense. There's a lot of pain involved and a lot of stress. But, this is something that criminal defense attorneys have to deal with every single day. Are their clients going to be mad because they didn't get a good enough deal versus prosecutors where everybody's mad because they put a loved one in jail and they're going to come for them. Particularly when I was prosecuting and working on children assistance cases where, we had to take care of the children, and families and parents get super mad about that, which is understandable. But then, they don't make the best decisions and they come after you and your children. So, I mean, it can get dicey, everybody. It's a tough business. So I'm very thankful for those that work in the business. I'm very thankful for that. And hopefully these kinds of things will be followed up on and people will be held accountable in this situation. But, like Judge Ingron was saying on the record, he was saying this could have deadly consequences. And many people were saying, come on, let's be real. It's not that serious. But it really is. It absolutely really is. We all go a little mad sometimes. Absolutely. We absolutely do. For sure. You got to keep the Hulk in. The Hulk is not supposed to be coming out. You're going to get into some trouble. You know what I'm saying? So, yep. It takes a toll on you after a while. Yeah, January. Yes. I gotcha. So that was the last document I've got for you, everybody, for tonight. Again, let me show our calendar one more time here. Oh, I won't bore you with my war stories. Oh, my goodness. Oh, UK. Hello. Welcome. So again, for tonight, we did a little catch up here, went through that gag order that was reinstated. Tomorrow, I will probably be back on a live, going through the Colorado, listening to that a little bit more tomorrow. We've got Don Jr. and Eric both scheduled in the New York case to be testifying this week. A couple of briefs and hearings in Georgia, which should be televised. So that will also be very interesting. And we will see what comes up. And then on Monday, of course, we've got Mr. Trump due to testify in New York. So that's what we've got going on here. Yes. So I will be back again tomorrow, everyone, 7 o'clock Central Time. And I will be doing an update on what's happening. Again, just for anything that's been filed, any new motions or orders, I will start with that. And then I do have some transcripts from the Salem witch trials that I will be going through as well. So for anyone who is interested and wants to hang out, should be very interesting and enlightening. We'll kind of do a little memorial for the lack of justice that had been going on in the 1600s. So we'll take a little bit of time on that tomorrow. So at this point, everybody, I'll go ahead and say my goodbyes. Yes. Oh, I'm looking forward to it. It's very interesting. I have gone through it. So I needed to make sure I understood what the language was and what all the different devices were that were being used. So we will modify it. We'll modify it a little bit here. Make it family friendly as best as I can for the Salem witch trials. We'll see what we can do. But that will be tomorrow. So 7 o'clock, everybody. And as always, thank you so much to my amazing moderators. I'm so thankful for your time. Oh my gosh, I just can't thank you enough. I will be back again tomorrow, during the day probably, and then in the evening for sure. Please record. Yes, I do put all of my lives up on my Tube of You channel, although it's a little bit slow. The line is long to get them up at this point, but I will have them up as soon as possible. So have a great night, everybody. I will be back again tomorrow for a special Halloween. Yes, we'll see you tomorrow, everybody. Have a great night. Thank you again for coming by. Always good to see you all.